It's worth it trying out, so you just drop it into the basket. All right. Come here. Here you go. Now we're ready there. See you later.
Elizabeth, are you a secret judge? You're getting that. It's going to be a bit cracked.
What's that last minute decision to have it in the
social distance.
Okay, we ready to get going?
Council, are we all ready? Yep. The live streaming is on. It's ready when the judges are ready.
The judge definitely knows this course, right?
because she was rushing around so much.
Changed at the last minute. The courtroom gets changed.
Not the last minute, no, they told us last week.
Because of the water, right? Because of the water.
Yes, that's right.
It's one over there.
Hiding over there. Right. Okay.
All rise. Proceeding in the matter of Nikolaeva and London Borough of Redbridge.
Yes, Mr. Chataway.
No, please, Your Lordship, Your Ladyship. I appear for Ms Nikolaeva, Mr Mullin, Ms England, here for Redbridge. And this is the appellant's second appeal against a decision by the Respondent's Reviewing Officer of 6th of December 2018. Appeal dismissed at first instance by His Honour Judge Luba QC, and then permission to appeal granted by Lord Justice Floyd in April. And in substance, the decision that we're concerned with is a decision that the housing duty under Section 193 of the Act has come to an end. That duty is referred to in the Act as the main duty, the main housing duty. It's certainly key to the appellant because it's the duty under which she has been housed for the past 16 years. And it's said that the duty came to an end because of the refusal of an offer of social housing allocated under Part 6 of the Housing Act 1996. The gist of the appellant's case really is this. I mean, it's accepted that there was a refusal in that the appellant did not sign a tenancy agreement on 29th of June 2017. But we say that's not sufficient to bring the duty to an end, really for two reasons. The first is because this was a final offer under Part 6, and we'll be looking at it in a moment at what that means. But there are two requirements for a final offer. One is that it be an offer which is reasonable to accept, and also there's a requirement that in statutory guidance that an applicant be given a reasonable period for considering a final offer. And we say that on the 29th of June, the tenancy was in effect sprung on the appellant, is what the judge called a truncated or compressed process, where she was told to sign up on the spot. And when that point was put to the reviewing officer, he sought to answer it by relying on a finding that there had been a second refusal 5 days later, for which we say there was no basis in the evidence. So that's the gist of the first
second
point.
Refusal or continuing refusal?
Well, I'll come to that, but I'd be submitting that he needed to find there was a second refusal, because continuing refusal doesn't really make any sense in terms of the framework of the Act. The second reason we say that the review officer couldn't rely on this further refusal is because by that point there'd been an issue raised as to whether the tenancy being offered was still available, and that the review officer failed to look at that, and he couldn't be satisfied the duty had come to an end without addressing it. Because it's a second appeal, I'm going to be focusing very much on the review decision, but of course I'm going to have to deal with what the judge said below, not least because it's on HHJ Luba QC, who's designated circuit judge and has exceptional expertise in homelessness matters.
Yes.
And my plan really is to start by looking first at the law and the guidance in quite some detail, and to focus on three issues. One is an issue that was really raised by the judge, has since been picked up by the respondent, as to what's meant by an offer in section 1937. And in outline, the dispute is that the respondent says it means really no more than an allocation or a nomination to a property. And we say, well, it means something much more concrete than that. If it's not the contractual offer of a tenancy, then, as the review officer put it, it is nevertheless intrinsically linked to the concrete offer of a tenancy. And we say, well, just as the review officer said, it can't be accepted without accepting a tenancy, we say it can't be an effective offer unless it's coupled with an effective offer of a tenancy. The second issue I'll be looking at is what's meant by refuses. And the third issue, we'll be looking at the effect of the statutory guidance and what's meant by this requirement that an applicant should be given a reasonable period for considering a final offer. And in summary, I submit that involves an opportunity to consider tenure, the terms of tenancy, and all the particulars of the offer. It's all really about Housing Act 1996, and I'm going to start by looking at, we've got various sections in the Joint Authorities bundle, and I'd ask your Lordships, your Ladyship, to turn to page 3. And there are really two parts of the Act that are relevant. There is Part 6 and Part 7. And to start with, Part 6 deals with the allocation of social housing. And what that means is really explained in section 159, which is here. And this is right at the beginning of Part 6, and you'll see 1591 says local housing authority must comply with the provisions of this part in allocating housing accommodation. And what that means is explained in subsection 2. So a housing authority allocate.
I'm so sorry, I don't seem to have section 159. Mine is at section 175 page 3. Don't worry, I will. I'll just listen.
We've got a. I don't know if it helps that we have a memory stick with the electronic copy of.
No, thank you.
So at 159, a local housing authority allocate housing accommodation when they do one of three things. So A is select a person to be a secure or introductory tenant of housing accommodation held by them. So in other words, the local authority is granting a tenancy from its own stock. B is where they nominate a person to be a secure or introductory tenant of housing accommodation held by another person. And because that's dealing with secure or introductory tenancies, what that really means is another local authority. And then C is the one that is more relevant here, nominating a person to be an assured tenant of housing accommodation held by a private registered provider of social housing or a registered social landlord. I mean, typically what that is a housing association. But what those all are about are social housing. So it's long-term, what one might call settled housing, typically distributed through a waiting list or some kind of bidding mechanism. And importantly, Part 6 doesn't impose any duty to secure housing for any individual. What it does do is contain rules about how the local authority should choose who to allocate to. So it's no surprise that the word offer doesn't appear anywhere in Part 6. That's Part 6. What we're concerned with is Part 7, which deals with the duties applicable to homeless people. And by contrast, what Part 7 does is it contains a series of different duties that may arise towards particular applicants. And in some cases, as we'll see, they impose a duty to secure accommodation for a particular applicant. And the main duty that we're concerned with is section 193. And the version that applies to Ms. Nikolaeva is at page 6 of the authorities bundle. This is the version that was in force up until about 2009. There have been various changes made since, but there are transition that keep this version in effect.
I'm so sorry. This is the version which applies to Ms. Nikolaeva,
Yes.
and you just said it was in force in 2009.
Up to 2009.
Okay.
That's right. I've included later in the bundle the current version, which I propose to look at briefly after. Often referred to in the cases of full duty, actually the way it's referred to in the Act itself is the main duty. And the conditions for it arising are listed in subsection 1. And the framework is broadly that if an applicant applies and if there's reason to believe that this or some other duty is owed, local authority has to conduct inquiries and satisfy itself about certain issues. And when it finds that these conditions are met, section 193 duty arises. Your Lordships will see in subsection 1. This section applies where the local housing authority is satisfied that an applicant is homeless, eligible for assistance, and has a priority need and are not satisfied. He became homeless intentionally. Just very briefly, to say a word about what those criteria are. Homelessness is a defined term, but it broadly speaks for itself. Eligibility is about immigration status. Priority need is again a specified term. It might arise because the applicant's got dependent children. Broadly, applicants without dependent children are only a priority need if they have physical or mental health issues. And the test is whether they are vulnerable. And then lastly, that they've not made themselves homeless intentionally. And then the duty itself is contained in subsection 2. So unless the authority refer the application to another local housing authority, they shall secure that accommodation is available for occupation by the applicant. The referral mechanism is not relevant here. It's to do with local connection to different areas.
Can we just go back a minute or two, Mr. Chatterway? You said that homeless is a self-evident word. I'm not sure that it is, although your client has in fact been in the same local authority flat for 16 years, hasn't
Yes.
she? But she is nevertheless homeless within the meaning of this section.
Which she was.
She was.
When she applied.
Right.
And the authority was satisfied that the duty arose. As we'll see, the duty doesn't end simply because an applicant is accommodated. If they are provided with temporary accommodation, the duty, the section 193 duty can continue, and indeed will continue, well, can continue indefinitely.
Yes.
And one sees in subsection 3 that the authority is subject to the duty under this section until it ceases by virtue of any of the following provisions of this section.
I see. So she was homeless in 2004.
Yes.
Applied, got the flat, but the duty by virtue of 1933 continues unless refusal, etc., kicks in.
Exactly.
But potentially for life.
Well, potentially.
Okay. Thank you.
Now, in terms of its cessation, the triggers, if one, so to speak, for the duty ending are listed from subsections 5 through to subsection 7b. And if we look at this, I mean, there are 8 basically what the judge called exit routes that will bring the duty to an end. And looking at them fairly briefly at this stage, the first of them is 193 subsection 5, which states the local housing authority shall cease to be subject to the duty under this section if the applicant, having been informed by the authority of the possible consequences of refusal and of his right to request a review of the suitability of the accommodation, refuses an offer of accommodation which the authority is satisfied is suitable for him, and the authority notify him that they regard themselves as having discharged their duty under this section. It's been held really that this subsection is concerned with refusals of temporary accommodation. So in other words, if an applicant like Ms. Nikolaeva is offered temporary accommodation, as she was back in 2004, acceptance of it doesn't bring the duty to an end. Refusal of an offer of temporary accommodation can do. And then next one sees in subsection 6 five different circumstances that will bring the duty to an end. The first is if you cease to be eligible in terms of immigration status. B is if you become intentionally homeless from accommodation made available. For example, you're in temporary accommodation, you don't pay the rent, get evicted. C is if you accept an offer of accommodation under Part 6, allocation of housing. So one can see the way here that Part 6 and 7 work together. If an applicant is accepted as homeless, housed and then offered social housing, and they accept it, that brings the homeless duty to an end. And then double C accepts an offer of an assured tenancy other than an assured short-hold tenancy from a private landlord. Just to pausing there, as Lordships may know, that the assured tenancy regime is the statutory protection that applies to private tenants and housing association tenants. And there is basically a full assured tenancy that can only be brought to an end on defined grounds, such as breach of tenancy plus reasonableness condition. Within that, though, there is an assured short-hold tenancy, which is the usual form of private tenancy, which can be brought to an end on a no-fault basis through service of a Section 21 notice. I explain that because it's of some relevance in this case.
And that was what was offered here?
Yes.
Yes.
Yes. And then D, otherwise voluntary ceases to occupy accommodation made available. So they basically abandon temporary accommodation. And then, more importantly, the trigger that we're looking at, which is in subsection 7. Housing authorities shall also cease to be subject to the duty under this section if the applicant, having been informed of the possible consequence of refusal, right to request a review of the suitability of the accommodation, refuses a final offer of accommodation under Part 6. And I intend to come back to what offer means. But for now, what I'd draw the Court's attention to is what's said in subsection 7F, which says a bit more about final offers and when they can be made. So the local housing authority shall not, A, make a final offer of accommodation under Part 6 for the purposes of subsection 7, unless they are satisfied that the accommodation is suitable for the applicant and that it's reasonable to accept. And it's been held that they are distinct tests. And then lastly, the last trigger is in subsection 7B, which says the duty will cease if the applicant accepts a qualifying offer of an assured short-hold tenancy, which is made by a private landlord in relation to any accommodation which is or may become available for the applicant's occupation. And broadly, just to summarise what that is about, qualifying offers were private tenancies that fulfilled certain criteria, and I think one of them was that they had to be 2 years, minimum term of 2 years. And like a Part 6 offer, if they were accepted, they'd bring the homelessness duty to an end. But in the law that we're, in the version of Section 193 that we are looking at, there was no obligation to accept them. So they could be refused by an applicant who would say, no, I'd rather stay in my temporary accommodation for now, thank you. And that wouldn't bring the homelessness duty to an end. That position has since been reversed, in effect. So, as we'll see shortly, that the current Act provides for a very similar thing, which is called a private rented sector offer, which will bring the duty to an end if it's accepted or rejected.
But the sanctuary are not a private landlord,
no.
they're a registered social housing.
And we're looking at part 6, which, as I say, is social housing. Before we look at offer, there's one other provision that I'd ask the court to look at, which is at page 22. And this is section 206 of part 7. Which is headed discharge of functions of the local housing authority. And the court see it, subsection 1, the local housing authority may discharge their housing functions under this part only in the following ways. Clear discharge here means either carry out or bring to an end. I mean, it's that wide. And there are really 3 ways of doing it. The first is securing suitable accommodation provided by them, in other words, provided by the local authority itself, is available, or B, securing that he obtained suitable accommodation from another person, such as a landlord, a private landlord, housing association, anyone else. Or C, and much less used, by giving him such advice and assistance as will secure that suitable accommodation is available from some other person. But importantly, I say they're all, they spell out that the duty is all about securing accommodation. And that's really what makes part 7 wholly different from part 6, which is about having a fair process for allocating. If we turn back to page 6 and to section 193, I want to address really the point about offer, and which my learned friend says is really about allocation. It's the same thing as allocating, and it may or may not lead to tenancy if it's accepted. I mean, I say it's really artificial to distinguish between the offer that's involved in section 1937 and an offer of a particular tenancy. And therefore, when the guidance talks about having a reasonable opportunity to consider an offer, it means an opportunity to consider the whole thing, the accommodation, tenure, terms of tenancy.
But that's not what the subsection says. It uses the word offer of accommodation.
Yes.
It draws a distinction between that, for example, and offer of an assured tenancy. So when it says offer of accommodation, doesn't that mean something different from, and also the terms of the tenancy?
Well, I'd submit there are three reasons why it doesn't. I mean, the first reason really deals with my learned friend's approach. Offer is not just in section 1937. I mean, of the 8 exit routes, it's in 5 of them talk about acceptance or refusal of an offer.
Well, some talk about offer of accommodation and some talk of the offer of an assured tenancy. It may be helpful not just to use the word offer and forget the rest of the statute.
Well, yes, but the point is that the triggers are not all about social housing. Mm-hmm. I mean, there are, the word offer is used about social housing, but also about private tenancies. So it really is a very different thing from part 6. And one can't therefore, certainly, part 6 really isn't about offering. It doesn't say the word offer, and it's not really about securing accommodation for people. So I submit, part 6 really can't provide a sensible guide as to what offer means. As your Lordship says, one really needs to look at section 193 itself and how it works. And that's really the second point, that I say offer can't just mean allocation because of the way it's used throughout section 193. So if we see, for example, first, subsection 6, double C. Here, offer is expressly said to be offer of an assured tenancy from a private landlord. It's not offer of an assured tenancy with a private landlord. It's actually the offer comes from the private landlord. And if we look at 7b, it's even clearer, because there it talks of a qualifying offer of an assured short-hold tenancy which has been made by a private landlord. So it's clear that there, the offer, the word offer, is really being used to describe the offer of the concrete tenancy that is made by the private landlord. And if we turn back and look at, for example, 6C, there's no reason to read that word any differently, because there 6C talks about an offer of accommodation under Part 6, which will involve the grant of a tenancy. That might be a tenancy from the local authority itself, it might be an assured tenancy from a private registered provider or a housing association. But where the other provisions are specifically talking about the offer and saying, look, in particular, we mean the assured tenancy, one ought to interpret the word offer consistently and say, well, what this is talking about is the offer of the tenancy that it's referring to.
Could you just help me with why we are worrying about this? Are you saying that the offer means both the physical accommodation and the terms of the tenancy, and until you know the terms of the tenancy, the period of reasonableness under the statutory guidance doesn't begin? Or are we looking at this for some other reason?
We're looking at it partly for that reason. But it also goes, I say, to the second ground, really.
Which is what?
Which is that whether an offer to be effective has to be an offer which, if accepted, will give rise to a tenancy. Because, as we'll see, the gist of the judge's reasoning there was, well, look, as long as the there is an offer made by the local authority, it's effective, whether or not.
Attention please, attention please. This is the Security Control Office. You are now invited to observe a 2-minute silence to mark the anniversary of Armistice Day.
Lordship asked a very fair question. Why are we looking at this? As I say, it's of some relevance. I don't put it any higher than that to ground one, because it goes to what's involved in considering an offer. But I think it's of more central relevance to ground two, because I say an offer can't be effective unless it will give rise to a tenancy.
But it would if here, certainly on the 29th and possibly on the 4th as well.
Possibly on the 4th.
And that's your point,
And
is
that's
it?
the point,
Right.
exactly.
Okay, just so that I know.
Just going back to the question of versions of the statute,
Yes.
as you said, in 2004, when Ms. Nikolaeva first got her present tenancy, Section 193 applied to it in the version on page 6. And so we've been going through pages 6 and 7 line by line, and I've been annotating them. But does that continue to be
Yes.
the version that applies to all parts of this transaction, as it were?
Yes. And indeed, if her case is reconsidered, it will be this law.
Still
that
this
has
law.
to be applied. Because
Right.
the transitional provisions say basically it depends on when the duty was accepted.
So you've given us the 2018 version simply for our education, but not because it, and it's very useful, but
Yes.
but it's not because it now applies or would apply on a reconsideration.
No, it only shows that the issues we're looking at remain relevant for other applicants.
Thank you.
So I say if offer is expressly linked to tenancy in those bits we've been looking at, 6CC and 7B, then it really must mean the same thing when one is looking at the bits that talk about an offer of accommodation under Part 6, because Part 6 will involve the grant of a tenancy. And if one thinks about cases where the Part 6 allocation is of a secure tenancy from the authority's own stock, then there's a direct parallel between provisions like 6C and 7, which talk about that offer, and the offers of a tenancy under the other provisions. But even where the offer, or rather, even where what's happening is that an applicant is being nominated to another organisation, a housing association or another authority, there will still be a tenancy. And it would be striking if the offer that the Act is talking about there is a very different thing from the offers of tenancy.
What can be the reason for knowing the terms of the tenancy from the social registered housing person? There's got to be a review of the suitability of the accommodation,
Yes.
and that must mean the physical accommodation. There has to be, for your ground two, an actual tenancy, otherwise there will not be a securing of the accommodation because there is none available. But in terms of knowing the terms of the tenancy, what you need to know is you're being offered this flat on social housing terms. You can't say, well, I'm sorry,
Yes.
I don't like clause 6, or I'm sorry, I don't like clause 4. That isn't going to help you, is it?
Well, unlikely to, but there may be relevance to suitability, and the point is that if they are part and parcel of the offer, then the appellant at least has the opportunity to look at them, consider whether they are suitable and whether there's an issue about them.
But
As we'll see arose in this case.
But just say review the suitability of the accommodation, refuses a final offer of accommodation. This is looking at social housing in this case.
Yes.
She's unlikely to get a different, more beneficial set of terms for one flat within this registered housing complex.
That's right, but we'll see there is confusion that arises in this case about what sort of tenancy she is being offered, and I say that that's something that she ought to have been entitled to consider, at least, because the confusion, particularly to someone like her, was alarming. We'll come to it. For the moment, staying with what offer means, I say there's a third reason why it's got to mean something concrete. And this is the point which the judge referred to below somewhat dramatically as the guillotine point. And it arises because, as we've seen, in 5 of the relevant triggers or exit routes for bringing the duty to an end, the Act talks about the duty ending upon acceptance or refusal of an offer. And the way that the judge articulated it, he referred to a decision of Mr. Justice Haddon Cave as he was then. It's in a case called FISI, which is at tab 9 or page 136 of the authorities bundle. And sorry, the report begins at 133, but it's page 136 that contains the relevant passage. And we'll see at the bottom of page 136, there's a reference to the words within 1935 that say the local housing authority shall cease to be subject to the duty if the applicant refuses an offer of accommodation. And I'd invite your lordship, your ladyship, to turn over the page and read the first 2 sentences the first sentence in paragraph 70.
I'd be grateful, Mr. Chataway,
Yes,
if you could read it out,
course,
because it appears that I've been provided with the wrong authorities bundle. So I'm writing very detailed notes of everything you say.
Yes.
And I will have to look them all up later. So please would you read those sentences to me?
There's a spare which my judicial assistant has. No, not the authorities. So we have any number of copies of the supplemental bundle, but not of the authorities bundle. That's.
My lady, my Junie has an unmarked authorities bundle that she's.
If she's willing to
heavens,
sacrifice
thank you very much
it, that would be.
indeed. I'm very grateful, thank you.
Is it the whole bundle you have, or just it's the whole bundle? If
Thank
your
you.
junior's willing to make the sacrifice in respect of the whole bundle, that will save a lot of trouble.
I'm sure she is.
If she's written anything incriminating on it, then take it out.
I'm sure not.
I'm extremely grateful to you. Can I hand... Thank you.
So that just slides in the back. So there are tabs in there. So if you just open the file, and behind the second tab, it's the space for it there.
Thank you. This is the remainder. This is your actual... I'm sorry to interrupt. This is your copy of the decision, the review decision, etc.
Everything is in there. So the
Yeah,
court
but don't you keep that, and I will put this through the holes of the authorities. I don't want to deprive you of everything.
It's absolutely fine. I actually have an electronic copy, so that.
Okay. Well, I will just put this through here to keep it together. I'm sorry to have
No, that's fine.
caused a hiatus.
So, my lady, we were looking at page 137. At paragraph 17, where Mr. Justice Haddon Cave says this: the subsection provides in terms that as from the moment of refusal, the duty of the authority ceases. And then at paragraph 19 in the marked passage, the only duty to provide accommodation is that either section 188, the interim duty to accommodate in case of apparent priority need pending a decision, or the full or limited duties specified elsewhere to accommodate, but a guillotine comes down on the duty to provide accommodation following the applicant's refusal of an offer of, on this hypothesis, reasonable
Probably this, Mr. Chadwick, this is considering whether or not a different duty exists after the refusal, and the answer is no. This is really, I don't understand why this is so critical, because here there is a factual question. When was the refusal made? Was it the 29th of June? If the authority says, as for example in the employment context, I know you said in the heat of the moment, no way, but please go away and think about it, and we'll keep it open until the 4th. And she comes back and says, if that's the fact, on the 4th, no, I'm still not prepared to have it. The authority are not treating the first refusal as the final refusal, they're treating the second effect. So, although I understand there's a guillotine, at the moment I'm finding difficulty in relating, with the greatest respect, the abstract points of the nature of the duty to the facts of this case and how it helps analyse this case.
It just goes to the point, well, it goes to my argument that the duty has to be effective. In other words, the refusal relied on has to be of an offer that is open and will give rise to a tenancy.
Yeah. Okay.
And that's what it goes to. And the reason I say it might mean that is because if the guillotine comes down at the moment of acceptance, then it must mean that if the offer is accepted, that will result in a solution to the housing problem. And that's why the 193 duty ends at the moment of an acceptance of an offer on the part 6. And that shows that what is meant by offer under part 6 means an offer that will result in a tenancy if it's accepted. That's the point that I seek to make from that. It's not a mere nomination.
Is it relevant that this was a decision on an application for an interim injunction that the defendants continue to accommodate the claimant pending her Section 202 appeal?
That the circumstances of that case are different, but what I seek to draw from it is the point that the judge drew from it below, which is that the duty 193 duty ceases from the moment of refusal or acceptance, and I say that is relevant both to what an offer means and also what a refusal means.
Your point is very simple, isn't it, Mr. Chadwick? You're saying that an offer has to be capable of acceptance. Just separately, just a point, and that is reflected in the fact that Mr. Justice Nikolaeva, as he then was, found that there was a guillotine, because it is, the question is resolved if the offer is accepted, but it has to be something to accept.
Yeah, exactly, and it has to be not a mere proposal that you may or may not get a tenancy elsewhere. I say it has to be an acceptance that will result in an answer to the housing problem.
And although your tour of the provisions, of course, is very helpful, that is what is actually expressly stated in the letter of the 19th of May.
That
in the 19th of May letter, it says this is a final offer of accommodation under section 1937, etc., 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 because we're nominating you for this particular property address given, 1 bedroom, ground floor flat, etc., etc. And in effect, it says that will come to fruition
if you're offered
offered it.
Exactly.
So there it is. That was obviously what Redbridge thought, and it fits perfectly with what you're saying.
Exactly. Yes.
Yep.
There is just one. I won't take the court to it because the point is clear. But I've included in the authorities bundle a case called Griffiths and St Helens, which just illustrates that the point. And I just would refer or ask the court to note on the marked section page 98 to 99 of the bundle, which spells out that of those 8 exit routes or triggers, that the whole point of the acceptance provisions, including the bit that says acceptance for Part 6 offer, is that they are there because the applicant will cease to be homeless.
It's an offer of accommodation. If there's no house there,
Yes.
if the housing authority are not going to rent it to that person over their dead body,
Yes.
then it's not a meaningful offer of accommodation. I don't see
Yes.
that the tenancy point adds anything. The duty will not have been discharged.
Yeah. I think that
Yeah.
I see we spent enough time on that point. We want to turn briefly to what's meant by refuses, and this I think involves, well, looking back at page 6 on the authorities bundle at section 193 itself. And I've really just got a simple point to make here, but an important one, I say, which is that refusal means more than a failure to accept. That's what section 1937 and 1935 say. They use the term refusal, and of course, a refusal might be inferred. It might be that somebody's given a deadline, a reasonable deadline, to make their mind up, and they're told that if they don't sign a tenancy by that date, they'll be taken as having refused. But nevertheless, the mere failure to reply or the failure to ask for a tenancy or to accept it in itself can't be enough. There must be some particular act or omission that amounts to a clear refusal. And that, I submit, fits with the guillotine point, because one needs to be able to point to the moment in time when the duty comes to an end and the guillotine comes down to finish it.
Well,
So
why? I mean, that's very important. And of course, you're right that failure, as a matter of ordinary language, a refusal is not constituted by inertia. But why is it wrong to say the appellant refused to sign the tenancy agreement when it was put in front of her, and that refusal was maintained?
But in that situation, I submit that the authority needs to find that there is a point in time when all the conditions for cessation of the duty are met. In other words, there is a refusal, a positive refusal. There has been, if the local authority is following the guidance, there has been a reasonable opportunity for the applicant to consider the offer, and at that point the offer is reasonable to accept. If the authority can say those conditions are all met at any particular point, then yes, the duty comes to an end. But if they're not met at the start of a process, it really doesn't take things any further.
But doesn't that logically mean that if you're offered a tenancy, as it were, on the spot, you say absolutely not and walk out, that the duty is never discharged because things didn't happen in the right order. You could have asked for a reasonable time to say whether you accept or not, but you didn't. You refused. Bang. That's it. You say the duty can't be discharged because she hadn't had a reasonable time. So that offer becomes wholly ineffective because it's rejected on the spot.
Well, I'd submit the court ought to be wary about thinking of it in abstract terms. I mean, if at the meeting there is left open the possibility of the tenant asking for more time or going away to think, that might be one thing. It might be then saying, well, actually, in all the circumstances, that person was given the reasonable opportunity to consider. They didn't take it. But there'll be different factual circumstances. And in this case, we say that that's not what happened. Actually, the tenant was told, sign up on the spot for a tenancy to start today.
Yes, but subsection 7 is when the duty ceases and there are a certain set of factual preconditions that require. It's not the authority having to make all these decisions and identify guillotines. And you have to look at what happened. There was an offer of accommodation on the 19th of May. Of course, until a tenancy came from the sanctuary people, it couldn't have been realised. She did visit the property and was considering the offer of accommodation. A tenancy was then offered, which she refused to sign on the 29th, and again was not prepared to sign on the 4th. And the question is, was the offer of accommodation given on the 19th of May? Do you look at the period of time that she had from the 19th of May onwards to see if it's reasonable? Are you able to infer either from her refusal, if you call it that, on the 29th, and or the maintenance of the refusal on the 4th of July, that that refusal was being maintained? And if you answer those questions, that's fine. If you can't even be sure if it's the 29th or the 4th of July, it doesn't matter, as long as by the 4th of July it was clear.
If there's a reasonable basis for finding that there was a refusal, a particular act or omission on the 4th of July that amounted to a refusal, then yes.
And that's a question as to whether or not you infer her refusal to sign the tenancy on the 4th of July again, when she said she wouldn't take it, is a maintenance of the refusal, isn't it? I mean, it's a factual question.
And that's, I'm afraid, where the hypothesis departs, I submit, from the reality. Because when we look, as we will, at the evidence of what happened on the 4th of July, it doesn't support there being the sort of refusal that is contemplated for in section 1937.
But when one looks at the 4th, and you're going to come to the facts, but when one looks at the 4th, one has to take into consideration also the letter which had been written on the 3rd.
Yes.
Nothing had happened. The 29th she said no, the 3rd she said no to the tenancy, and on the 4th they contacted her, and she's not saying, I've changed my mind.
And this is really about the facts, which we
all right, let's go to the facts. Enough of hypotheses. Let's have a look.
Yes, I would just ask that before we do that, I think we do need to look at the guidance, because the guidance sets out the test that one needs to apply. And I mean, very briefly,
somewhere in the Act there's a reference to guidance.
There is. And
Section 182?
Yes, it's page 5 of the authorities bundle. And you'll see obligation is in subsection 1. In the exercise of their functions relating to homelessness and the prevention of homelessness, the local housing authority shall have regard to such guidance as may from time to time be given.
Right.
The guidance that in force at the time is at tab 2, and guidance again is in substantially similar terms, but tab 2, page 28 of the authorities bundle. And it's paragraph 2.2. I just invite the court to read through the marked paragraph. And just to say a word about how this fits really with the scheme, I mean, there's no doubt that a large part of what Part 7 is concerned with is matching properties to applicants and simply looking at whether a local authority can decide that accommodation is or isn't suitable. But there are also protections in the Act and here that are, I submit, plainly intended to help applicants to make appropriate decisions about their housing. So we've got this requirement in the guidance. We've got various provisions in 193 about applicants being advised of the consequences of their decisions. And one needs to bear in mind that lots of people who apply for homeless housing are vulnerable, and indeed if you haven't got kids you will only be accepted for housing if you are vulnerable. And the threshold for applying is very low. I mean, there's a case that isn't in the authorities bundle, but WB&W decided in 2018, but in the Court of Appeal, says, you know, under the Mental Capacity Act, you can apply as homeless if you have the mental capacity with appropriate support to decide whether or not to accept an offer of accommodation. But there are people who fall into that category, who apply as homeless, who really do need support to make that decision. And that's why I say this is part of a series of protections designed not only to match suitable accommodation to applicants, but also to help applicants make decisions, appropriate decisions about their housing. And what does this guidance amount to? It amounts to a requirement that personal circumstances are taken into account, such as mental health issues. But I submit it's really all the circumstances of the offer that are relevant, and in some cases that might extend to issues about tenure, for example. And to make that point, I've included one case in the bundle at tab 4. It's the case of Mansour, which is an old case, and basically it's about the precursor to the 1996 Act. And there were, just for context, there was an equivalent, similar duty under Section 65 of the old Act to provide accommodation. And in this case, applicants have been accepted. They were offered assured short-hold tenancies. And it had long been believed that actually, in order to discharge their duty, the authority had to provide settled accommodation, social housing. But in a case called Awur, where Justice Hoffman had said, no, actually, the Act doesn't say anything kind, any accommodation can in principle be used. But I'd ask you to turn to page 47 and just read the marked passage from Lord Justice Evans, beginning with the words, in other words.
What were the actual issues here, though? This wasn't a case about the meaning of offer of accommodation or refusal, was it?
No, what it says, I submit, is that tenure is relevant to the suitability of accommodation.
Well, we only know that. I mean, we can't take passages out of context and say, look at those words fit here. What was the actual issue?
As I said, the issue is whether an assured short-hold tenancy could be offered in discharge of the housing duty under the 85 Act. And as I said, there had been an understanding that only settled accommodation would do. And what the court did in this case is confirm that in principle that's not right. Other forms of accommodation may be suitable. And this passage, I say, it just spells out that although that is right in principle, tenure does go to whether an offer will be suitable.
But aren't we straying a very long way from the grounds for appeal here? in the sense that it's not being suggested that this property was not suitable. That is not the question.
No.
The question is about the offer,
Yes.
and whether it was open to be accepted or whether it was refused.
But one of the issues, well, we say that part of the reason the appellant wasn't given a reasonable opportunity to consider things on the day, on the 29th of June, is because what the authority told her is you're going to get an assured tenancy. And actually, when she pitches up in the Housing Association's offer, what she's presented with is an assured short-hold tenancy. And she's told that...
that would have to be a case that an assured short-hold tenancy cannot be an offer for the purposes of...
of course it can. And if the appellant... And I'm not for a moment suggesting that it necessarily means the offer was unsuitable. But the point of all this is to show that that was a concern about an issue.
Yeah. There has to be an offer of accommodation. That's what she's got to look at. The physical accommodation has to be reviewed for suitability, not the terms. The accommodation has to be reviewed for suitability. I understand your point that unless there is a tenancy going to materialise, then there is in reality no offer of accommodation. I'm slightly bemused. Perhaps you could just help me. In what sense, on the facts of this case, is the question of tenure relevant to the grounds of appeal? Because
when the guidance says opportunity to consider the suitability, to consider an offer, I say it covers issues like this. If you're promised an assured tenancy, and in fact what you're offered is something that appears to be very different, then that is something that if you've got mental health problems and you're anxious, you ought to be given an opportunity to consider. And the point of referring to this...
But for how long, Mr. Chatterley? I mean, if the facts of the case were that she goes to, I can't remember where this took place, but a meeting takes place between her and an official of the local authority who says, here's the assured short-held tenancy agreement, that it's that or nothing. And she says, I'm not happy with that. And he says, right, and rings up Sanctuary and says, you can let the flat to somebody else. And so 10 minutes later, it's gone. One can see that that would be unreasonable. Most people would say that was unreasonable. But that isn't the facts. But you're saying that the period of at least 4 days after that can't be taken into account.
Not at all. I'm saying that if it had been open to the reviewing officer to make a sound finding that the offer had been restated on the Tuesday, the 4th of July, and refused at that point, that would be the end of the matter. But that's not what happened.
Three things happened. She went, a number of things happened, but ultimately she said, I'm not signing that tenancy, and she'll only get the flat if she gets the tenancy. Then then she wrote the letter saying, I'm not agreeing with these rules, I want my plants, I want the cupboard, I want the bike shelter, and so on. I'm not agreeing with these rules. They then contacted her on the 4th, knowing that the authority was saying, well, look, if we're going to have to take it back, we will take it back if nothing happens. And on the 4th, she didn't change her position. And by the 7th, they had taken it back. Those are the facts, really. And I don't understand.
Yes.
It's just a question of, was there an offer of accommodation?
Yes.
Was there a refusal on the facts? Had there been a reasonable time between the 19th of May and at the latest the 4th of July, if it was available, or the 29th of June if it was not, to determine whether to accept it? Those are the facts.
Well, yeah. well, let's turn to the facts now. I mean, I would just say I don't accept that when we look at the evidence of the 4th of July, what I'll be submitting is that all one can soundly deduce from that evidence is that she was booked in for an appointment.
Well, that's fair enough. That's arguments about the facts.
Yes. Which
what
one?
I'm struggling to understand at the moment, and it's my fault, and I do apologise, what I'm struggling to understand at the moment
Yes.
is how discussion helps me and arms me. So when I look at the evidence, I know what it is.
Yes. Yeah.
And that's where I'm having difficulty.
I think we'll come back to it, but certainly if as Lord Justice Bean said, if I don't think I need to go any further than using all of this to show that the refusal on the 29th of June cannot be relied on. That's all.
All right, let's get.
And you're doing that on the basis of saying the guidance requires a reasonable time for a person to think. One of the things that they ought to be allowed to think about is the nature of the tenure, and she didn't find out about that until the 29th. Hey presto, accordingly, it must be that any decision made on the 29th could not be relied upon.
Exactly.
That's it.
In particular, given what the authority knew about her mental health issues.
Yeah.
That's it. And the facts, I should say from the outset, I think that the judge's summary of the facts, there's one minor detail that in my skeleton I've said he got wrong, he confused one interview note, but otherwise immaculate, great clarity, and precisely stated, and set out from paragraph 20 of his judgment. And in fact, if we turn to page 37 of the core bundle, looking through his account, I would just draw attention to his paragraph 22, which sets out the important background about Ms. Nikolaeva's mental health issues. And then just very briefly, in paragraph 24, he points that in July 2013, Ms. Nikolaeva successfully bid for and was offered a studio flat. However, after seeing it, she refused it. The recorded reason was, somewhat surprisingly, that she did not want a studio flat after all. And it's later what he refers to as the bizarre history. And I just ask the court to look in the supplemental bundle to the representations that were made by a friend at that time. It's at page 5.
But does any of that matter? Because we know that a previous offer was made, and having received submissions from a friend, the local authority concluded that they would not take the refusal as a refusal.
That's right. It's just, I think, noteworthy that actually it had been flagged up, even at that stage, that Ms. Nikolaeva was likely to need support in terms of what her friend submitted, was that she, I understand Ms. Nikolaeva will now be allocated a social worker who will hopefully assist her with all future bidding or provide support to do so. Unfortunately, that never happened. But flagged up then that she was likely to need support around decision making when it came to rehousing. And then if one turns to the history of this offer, the story really begins at page 6 of the supplemental bundle, which is the letter from Redbridge. And I just raised 2 points about this letter. The first is the point made by my lady, that the letter quite properly draws a distinction between nomination, which is the allocation under Part 6, and the contractual offer of a tenancy that will, if one like, complete the offer of housing, and that contractual offer is to come from Sanctuary.
This is the offer of accommodation. It's conditional upon the housing authority coming up with an agreement, but presumably the time from when she receives this is all relevant to reasonable time.
Yes.
Or you're not saying because of paragraph 2, if the nomination is successful and you are offered, this offer will constitute a final offer of accommodation. You accept that this is an offer of accommodation, conditional on Sanctuary providing it and agreeing it.
Yes.
But this is all, she can, the clock starts ticking from the 19th.
Yes.
Yeah.
Yes.
The second point, however, is that what is said to Ms. Nikolaeva at this point is in the second paragraph here. You will be contacted by Sanctuary Housing Association who will invite you to view the property. This nomination is, I think, to an assured tenancy.
Yes.
Is made under Part 6. In fact, I should say, these days, that's not, that used to be how things happened. Housing association tenancies were almost always assured tenancies.
Yeah.
These days, it is done somewhat differently. And these days, it is probably the norm that a housing association will grant a starter tenancy, or what they call a starter tenancy, or probationary tenancy. In other words, an assured short-term tenancy for a period, which will then lead to an assured tenancy.
There's no suggestion, is there, that means that this offer was in some sense not a legal offer?
No.
And there's no suggestion, is there, that Miss Nikolaeva said, well, I'm terribly sorry, I was told an assured tenancy, how can you offer me an assured? That is the case,
yes.
Is it? Right, okay.
We'll see that.
And speaking of, you say these days, the change had already occurred by 2017.
Yes. Yes. I'm not sure how widespread the practice was in 2017, but it was not uncommon. So as we know, that's the 19th of May, and we know that there is a viewing, which I think is on the 8th of June. And Ms. Nikolaeva goes away from that viewing believing that she's been promised a second viewing, although the reviewing officer... Well,
as a matter of fact, there's a dispute on that, and he checked and he says, no, it wasn't.
Yes. Which brings us then to the letter from Sanctuary, which is at page 8. And this really is the first of, I think, 3 key dates in this case.
But before we get there, in relation to the 8th of June viewing, it's right, isn't it, that there's a record of what happened then, and that there was discussion with the Sanctuary Housing Officer on that occasion about the details of the nature of the tenancy, in the sense of the clauses, what one was allowed to do and not allowed to do.
I don't think so. Perhaps help, but I don't think there's any record of what happened at that viewing. We'll see there are some references to it in Ms. Nikolaeva's letter, as what she says happened that date. And as I say, the reviewing officer found one thing, which is that there wasn't an offer of a promise to do a second viewing. But beyond that, we don't know.
Sorry, you were on the 29th of June letter on page 8.
Yes. And we'll see this is if you... And I think Lord Justice Lewis is right to say there's the earlier conditional offer, but in a sense it's completed by this letter I'm writing to offer you the tenancy. And importantly, this letter is plainly drafted as though it ought to be sent out to prospective tenants in advance. And we can see that because it says, third paragraph up from the bottom, it says, if you do not bring the required first payment to the sign-up, see, won't start. And then over leaf, on page 9, it says this offer is made subject to you accepting and signing the association's tenancy agreement. Both parties must attend when the tenancy agreement is signed. The paperwork at sign-up will take 45 minutes approximately. And then if one looks at the last paragraph on that page, it warns that you should consider this matter very carefully before making a decision to accept the tenancy. Attached is a form we will ask you to sign at the start of the tenancy to confirm. So plainly drafted as though it was sent out in advance. In fact, Common Ground, what happened is what the judge referred to as this truncated or compressed process. When the appellant's called in for an interview, she's handed the letter and asked to sign up then and there. And just ask that you note two things, your Lordship's Ladyship, note two things about the letter. First is, very top line on page 8, what she's being offered. I'm writing to offer you the assured short hold starter, 6-year fixed term tenancy. So that's the type of tenancy that can in principle be ended on no fault ground.
And if that had been referred to in the one in the 19th of May letter, that wouldn't have made it legally invalid. You can still have an offer for the purposes of
Part 6.
Yeah.
Yes, I accept you can. But also the start date, towards the bottom of page 8. The start date for your tenancy is 29th of June, in other words, today. And so what happens is appellant goes in, there's this meeting, she gets as far as paying a deposit, but she's told, here you are, you've got to sign up to this assured short hold today, and the tenancy will start today. And we've got two accounts as to what happened at that meeting. The first is at page 10. And this is basically an email from a lettings officer at Sanctuary, written on Friday the 30th of June, but from the second paragraph on, that's the word sign up for today, it sets out the account recorded by the housing officer who was actually at the sign up appointment with Ms. Nikolaeva. And I just ask the court to note really 3 points about this account. The first is penultimate paragraph. She became agitated. And that really, I submit, chimes with what the authority ought to have known about this case from before. It chimes with what had been said by her friend Mr. O'Donnell about her having long-standing mental health issues, suffering anxiety and needing support. Secondly, that her anxiety, much of her anxiety was focused on issues about security of tenure. And indeed...
Where do we get that?
Well, because it says at the bottom, it says she became agitated and advised she will put the plants out on communal grounds whether I like it or not. At this point I reiterated the terms of the assured short hold starter to her as part of her agreement.
And that's all about plants.
Well,
And the bit
that's
that she
right.
objects is the bit that says you've got the communal area clean and tidy and free
Yes.
from rubbish and other items.
Yes.
And if you read the opening bit, understandably she wants to go with her 20 pots
Yes.
of plants. And that's what this is all about. This is not a legal discussion where the lady is saying, I'm terribly sorry, I can't possibly agree with clause 3.1d. We'll have to renegotiate that. She's
No.
saying, I want my plants. They are saying, no, you can't under the agreement. And she said, I'm sorry, I'm having my plants.
Yeah, that's right. And
That's
I'm
what
sorry, I
it is.
apologise. I slightly jumped the gun because we'll see when we come to her letter that she links the two issues. But certainly the agitation here is linked to a discussion where the housing officer refers to her assured short hold starter tenancy. We'll come to what impact that has on her.
Well, let's suppose, just for the moment, that this is a true account of what happened.
Yes.
What do you say the obligation on Redbridge was?
I say the obligation on Redbridge was to say, look, okay, you were caught on the hop, I accept you're vulnerable, and you need some time to consider this. Therefore, you walked out of that meeting, you didn't sign the tenancy. We will give you an opportunity to reconsider. We'll give you 48 hours or 7 days or whatever it is. Go away, get some advice. If you don't come back by whatever deadline, then we will take that as a refusal. And at that point, it's a refusal of an offer which she has been given a reasonable opportunity to accept.
And that would have been 48 hours.
Well, that would be up to the local authority to decide what would be a reasonable period.
Yes, but you're saying that 48 hours would not have been unreasonable.
I think if they'd written to her the next week and said,
oh, that's
it'll be another couple of days, then yes.
So just remember, the 29th is a Thursday or a Friday?
A Thursday.
Right, so the 29th is a Thursday. On the Friday the 30th, Sanctuary tell Redbridge what's happened. So the flat hasn't been taken away over the weekend, it's there. Then she writes on the 3rd, and you're going to take us to that letter. And factually what happens is they try to call her on the 3rd in the afternoon. Is that Monday then?
Mm.
Yes.
And then they finally speak to her on Tuesday the 4th.
They do, and we'll come to the record of that meeting
Yeah.
in a moment. Before we move on, though, the offer, there is a point here about whether the offer remains open, because the offer at this point must be a contractual offer. And this is a tenancy. It's offered to somebody.
No, it's the offer of accommodation which manifests itself
Yes.
ultimately in a tenancy, but there really is no point in going through this. She's
agree.
being offered a flat, she's being told you've got to sign on the dotted line, and she's saying I'm not. That's the actual fact, no matter how one dresses it up.
I certainly the focus on the wider focus is on the offer under 1937, but the offer from Sanctuary is a contractual offer, which is said is rejected that day, and it's trite law that if a contractual offer is made and rejected, it terminates. And of course, that's where it's relevant that the offer was for a tenancy to begin that very day, 29th of June. So there is an offer.
When you say it's trite law, I'm not sure that it is. If you're looking at the position between Sanctuary and Mrs. Nikolaeva, their agent, let's call him, hands over a tenancy agreement and says, will you sign it? She says no. They don't say anything at that stage. Thinking back to all those cases one learned as a sort of first year student of the law of contract, if she goes back the next day and said, I've reconsidered it, here's a signed tenancy agreement, that probably would be a contract, wouldn't it?
I'd submit not, and especially when the offer was tenancy to start today.
Well, I think you've got to be realistic. This is a nomination by the local authority.
Yes.
The social houser have got to take the nomination unless they've got good reasons. What they say here is the sign-up didn't go ahead, paragraph 1. Please see the explanation below and advise another nomination, i.e. the sign-up hasn't gone ahead, please nominate somebody else, and then they set this out, and at the end they know that she's going to go back to Redbridge. So the reality is the matter is left hanging at the moment. Is the authority going to nominate somebody else, or is something else going to happen? And the reason why it's gone into the ground, according to this note, is because she cannot have her plants there. That is the factual situation.
Well, if one looks at it narrowly, she has her plants there, but one has to, I submit, not least because the guidance says so, has to take account of the mental health issue.
Very well. This
and the upset.
Lady who's got very serious problems and very serious mental health problems didn't want to accept the tenancy, and she was very agitated, in particular about the fact that she would be deprived of the opportunity of having the plants.
Exactly. I mean, in layman's terms, she freaks out. I mean, you know, she's told sign up on the spot, and she freaks out. And it fits with.
The question is, what happened next then?
Yes, of course.
But before you go to that, the last sentence, as my Lord Justice Lewis points out, the last sentence of that account of what happened, which is on page 10, is she didn't accept this. She didn't accept what I said about she couldn't have the plants, and was advised to return to Redbridge Council to discuss further. And as my Lord Justice Bean and Lewis have said, that isn't a guillotine by sanctuary at all. It's open-ended. She's returning to the local authority to discuss the situation. It's not been at that point, on the basis of that account, there's no hard-edged end as far as sanctuary is concerned at that moment.
No, but I would submit that if she had returned on the Monday to Sanctuary, for example, and said, sign me up, it's not clear that Sanctuary would have been bound to accept it. They might have said, well, actually...
They're a social housing officer. They've got an agreement with the local authority to take nominations. They've got to take a certain number of nominations, presumably, from the local authority. It's very unlikely that a social housing officer is saying, no, I'm terribly sorry, I've just looked at Chitty. We're not taking this. That's not going to happen in this world. And one other thing, I've seen reference to the word has advised is actually wrong, and what it should be was advised, i.e. that the person concerned was telling her to advise, or is that not correct?
I think it's written, well, it's written on the day, so it's on the 29th of June.
But the implication is that it was meant to be was advised, not that... The question is, did she advise Mrs. Nicolai? I'm going back to talking to Redbridge, or was she told to go back?
Yeah,
I understood it as has been advised to go back to Redbridge.
Well, then she writes the letter.
She does.
The next document, which is not just pot plants, the sanctuary a dictatorial regime. She wants nothing to do with them. But, last line, I do not refuse the apartment.
Yeah, yes, I agree. And of course, it's one of the ironies of this case that Ms. Nikolaeva, who originally sought to draw a distinction between the offer of accommodation and the offer of a tenancy, in a way we flipped now, in that I say that the offer of accommodation can't be understood separately, really, from the offer of a tenancy. The gist of the letter, as you said, is clear. It's not objecting to the accommodation, it's objecting to the terms. I just highlight two aspects.
But what she's really saying is, I'm not prepared to live in this property under those rules.
Well, I just would highlight two aspects. One is that it really chimes with what's said about the mental health issues and the vulnerability. And, you know, the way she puts it, halfway down page 11, is she says that when discussing the rules, our conversation turned into a dispute about rules that I did not understand, which led to a nervous breakdown. And then she says, you know, I'm told I can't change the colour of the rooms, the tiles, the gardening, etc. And she then says, I was in shock. But then over leave, and this is really where the link is to the tenure issue, top of page 12, first complete paragraph, the officer in the conversation showed all the time the rules that cannot be violated, and after 12 months my residence will be threatened with eviction.
I don't understand that, because I understood it was a 6-year tenancy, and there's the provisions for saying if you break the rules you could be evicted. And that would be correct, presumably.
Well, I mean, I think this is slightly reading between the lines, but the way that the probationary tenancies often work is that there's a probationary period where you remain on assured short hold for 12 months, and the agreement then becomes a full assured tenancy.
But it can't be that this duty continues when she says, I'm sorry, I'm not having a probation period, I'm not agreeing with the rules, I'm not agreeing with any of this.
Of course, if one looks about suitability, these issues go absolutely nowhere.
Yes.
But what one has to do is ask the question posed by the guidance. Did this particular applicant, in the light of her mental health issues, have a reasonable opportunity to consider the offer? And what I say is that when she pitched up to the meeting on the spot and was required to sign up, and there's a discussion about things she can and can't do, and she says that she's referred and told, if you break these rules, referred to all the details, if you break these rules, you'll be out, because it's a starter tenancy, a short, or we could do that. Then it brings in to issue for her the tenancy, and that's what she says later on, and she says halfway down that page, from the last letter, I'm writing to offer you this short hold, 6-year fixed term. But short hold tenancies offer no security of tenure. Short hold tenancies can be evicted after the end of the fixed period without any reason being given by the landlord. So, you know, they're important. Objectively, do they render it unsuitable? Of course not. But one has to think about the impact that issue. And that
so on the 29th, if it's a refusal, you say that it was too short notice.
Yes.
Assuming now it's not a refusal, which is a very short point, and it wasn't until the 4th that the shutters finally came down. She's been told on Thursday the 29th. 5 days later, when she's been thinking about this, in her very agitated state, she's written a new set of, or a fuller set of reasons on the 3rd of July, and they try and call her on the 4th and on the 3rd, and they can't get hold of her, and they speak to her on the 4th.
And the notes are at page 13.
Yeah.
But before we go to that, the penultimate paragraph on page 12, I should consider this matter carefully, which is what was also in the sanctuary letter, before making a decision to accept the tenancy. And I decided that I cannot agree and sign. So she's taking the point that she's meant to consider it carefully, that she was told on the 29th to consider it carefully. She has done, and on the 3rd she says, I cannot sign.
Well, one needs to be wary about reading too much into the tenses, I submit, because this is not her first language. And to be honest, the letter is at times obscure. And I just submit that...
I'm not sure that it is obscure, Mr. Chataway. It's perfectly clear to me. I am not prepared to accept any of these rules. I'm not refusing the apartment. If you let me move into it with no rules, and I can put my pot plants where I like, etc., that's fine. But I'm not going to abide by any of these rules. If that isn't a refusal, I don't know what is.
What I say is that it raises issues, including about the mismatch between the council's letter and Sanctuary's concrete offer. And really, when one takes into account their vulnerability, what it called out for is for someone in the local authority to discuss that with her and to give her a further opportunity to accept or reject. And if that had
They did that, they called her
on the 4th of July, then that would be one thing. But when we see the record for the 4th of July, there's no basis, I submit, for seeing that actually happened. The record is, the start, I think, of page 13 is where the trail starts.
Yes.
So one sees a series of notes, I think, made by an officer named Gracelyn. And towards the bottom, there's Monday, the 3rd of July, which is the Monday, letter received from applicant about refusing to sign. Rang applicant to let her know that we're not accepting her reason, but got no reply. And then if one turns over, there's the conversation with Sanctuary, who say they need a nomination by tomorrow. And then there's rang applicant again, 3:45, no reply. And then this is it. This is the only record of the 4th of July. 4th of July 17, spoke to applicant regarding a letter and refusal to sign the tenancy agreement. Applicant seeing YS on Friday, 9 AM in the HAC. We've got no idea how long that conversation took, and we've got no way of knowing what was discussed, save that we know applicant was told to come in and see Mr. Sharma, Yogesh Sharma, the manager, on Friday.
But if she had said, clearly the Sanctuary are pressing that they want the nomination, they're saying, look, if we don't get the nomination, we'll take it back tomorrow. They are chasing her to find out what happens, so they spoke to her. Is there any indication at all, any evidence at all, to suggest that she said on the 4th, I've changed my mind, I will accept them?
No, but from her point of view, I'd submit what one needs to find is a positive refusal.
Well, that came on the 3rd, and she's rung on the 4th because they said they weren't accepting her reasons.
Well, there are two ways of discussing a refusal. You can discuss it in the sense of, do you still want to confuse her? to refuse it, or you can discuss it as a historical event. You know, this is what happened. And if you've already refused it, then I'd submit that the failure to say, no, hang on, please can I have the opportunity to reconsider, does not amount to a second refusal, because it's not even clear then that the person realises it's still open. And that's the importance of the point saying that there has to be an identifiable act or omission which to amounts a refusal. And a sensible local authority...
Has your client ever made a witness statement saying, on the 4th of July, I actually said I wanted to accept it. I told them I changed my mind. She's never accepted it, has she?
She's not. No, well, that's right. But as I say, a failure to accept is not sufficient.
Well, let me put it more bluntly. She said on the 3rd, in clear terms, I'm not moving to this house with those rules. Has she ever indicated that her position has changed?
Well, no, because as we'll see, the next stage in the chronology is the 3rd key date, which is the interview with Mr. Sharma, and that's at page 15. And if one flicks to page 17 of the handwritten
starts at
notes,
16. She says it's not about the property, it's about the rules.
Well, it does, but the context for this discussion is that it's all history by now.
By this stage, because it has now been given to somebody else. Yeah.
And that's what's spelt out at page 17. The property has now been offered to another applicant. So what I say ought to have happened is that there ought to have been a discussion like the discussion that happened this day, when the issues about the tenancy, the tenure, the terms are discussed, and she is given an opportunity to consider the offer, and the opportunity to accept or reject it. But that's not what happened, because by the time this discussion takes place, it's already gone.
Yeah. And even on the 7th, she was saying it's not about the property, it's about the rules. She has consistently maintained her position up to and including the 7th, that she's not prepared to take the property on those rules. Well, the only question, therefore, is whether she had reasonable time on the 29th of June or the 4th of July to reach that position.
Well, what one is talking about here is the end of a housing duty. So there must be an onus on the local authority to satisfy themselves that the conditions for cessation of the duty are met.
And by the 4th, they say they had been, because by the 4th, she wasn't changing her mind, and that was it.
And that is where I submit that the your lordship's right, of course, the 4th is the key date. But the duty only ends, or the authority can only satisfy themselves that the duty is ended, if they find there is an actual refusal on the 4th of July. Not some discussion about the reasons why you refused it in the past.
There was a state of affairs where she wasn't accepting the property. We knew that on the 29th. We know it from the letter on the 3rd. We see it from the letter of the 7th. It really is very, very difficult to understand how you are suggesting that there is some different state of mind on the 4th, which is that, notwithstanding the rules, she's prepared to accept the property. That's what I have difficulty with.
I say that's really the wrong question. The question is, did she refuse it? Did she positively refuse it on the 4th of July, as opposed to have a conversation to book an appointment, or even a conversation where she explains why she did refuse it in the past? Because if you're invited to an appointment to sign up on the day, potentially starting that day, and you refuse it, I submit it needs to be made clear to you that you have a further opportunity to accept it before you can be taken to actually positively have refused. And that's where the evidence breaks down. Now, of course, these matters are...
But Mr. Chataway, the facts are different, aren't they? On the 29th, she refuses, but she's being provided with that, the details there and then. On that occasion, the attendance note, whatever you like to call it, says, in effect, I've advised her to go and discuss it. Before that happens, she has had the period from the Thursday through to the Monday. And on the Monday, she writes a detailed letter where she refuses, and she makes quite clear at the end of that letter that she was meant to have time to consider it carefully, and I have decided I cannot agree. And it's in that context that there's a discussion, however short or long, on the 4th. And so it's not as if it's an open-ended situation on the 4th. It's a situation which one must look at on the basis of what she has written the previous day, which has been received, because that's what the attendance note, the file note says, at the housing office. They've received the letter of the 3rd, and that's clear. And so one has to predicate that little note, and I accept it's a very little note, on the 4th, by the fact there has been a very positive refusal after a period of time which has already gone by. That's the reality, isn't it?
Well,
You're saying, despite that, there should have been a further discussion whether local authorities should have said, come on, please change your mind. That's what you're saying.
I am, and indeed, if that happened, if the local authority made a finding that is what happened, a sound finding, that's what's happened on the 4th of July, I agree, I'd be nowhere. But I'd submit the finding, and of course that's what's at issue, because it's not a decision for us or for the court, it's actually for the reviewing officer. One has to look at how the reviewing officer dealt with this issue. And the key point here is that the reviewing officer talked at length about the 4th of July. I say he recognised the importance of the 4th of July and looked at it and unfortunately he got it completely wrong.
All right, shall we go to his review letter
yes. Then? Before we do, there's just one very brief point I want to make about the lead up to the. Well, I think I do need to look a bit briefly at the representations to see what was in issue, because there's a dispute between my learned friend and me as to what the review position actually is, and therefore the context is important. So if one looks at page 104 of the core bundle, this is the first instance decision, the original decision about cessation of duty, written immediately after the interview on 7th of July. And the key point, the core of the decision, is at the top of page 105, reading from the last two sentences in the second paragraph. On 29th of June, you viewed 10A Redbridge Lane West, informed the Housing Association you were refusing. It was not suitable. You also sent a letter giving your reasons for refusal.
Sorry, are you on page 104?
105, so it's for the, in the body of the decision. And it's in the second paragraph, 4 lines down from the end. On 29th of June, you viewed it, informed the Housing Association you were refusing. You also sent a letter giving your reasons for refusal. And an interview was arranged, myself on 7th of July. So clear that the first instance decision focuses on 29th of June. No reference at all to 4th of July. There is then the request for review, an extended process, and in part because the review officer wants to try and contact Sanctuary to find out whether there was to be a second viewing, etc. And the CAB letter is the first. Page 1, sorry, in the supplementary bundle, we've got the representations that were put in. And I'm just going to take your Lordship's leadership very quickly through the various arguments that were run on the review. The first point is page 18.
just before we leave, Mr. Sharma's letter of the 7th of July, that says, no doubt this is part of a standard letter of this kind, in bold type, you've got 21 days and then that's it. You'll be turned out of your temporary accommodation, but in fact that didn't happen.
It hasn't happened.
No.
I'm not sure whether there's been a specific agreement to accommodate pending appeal, but potentially it's the COVID-19. But it hasn't happened, in fact.
Right.
In terms of the reps that are put in, it's the supplementary bundle, page 18, there's a CAB letter, and just emphasising, really focusing on the 29th of June. So, bottom of page 18, understandably, Ms. Nikolaeva became overwhelmed, confused, and extremely distressed. And then, if one turns to page 20, there's the first letter from her solicitors. And you'll see at the bottom of page 20 it refers to, in paragraph 2, to mental health issues, post-traumatic stress disorder, depression, severe anxiety. And then paragraph turns over to page 21, paragraph 8, reiterating what kind of state she was in at the original sign-up. Our client was becoming increasingly distressed. We instructed she was crying and shaking. She said she needs to know where the meters were, etc. And if one then turns over, top of page 22, 4 lines down, again this is the same meeting where it said that she needed to go and rest. On leaving she called the council in tears, did not understand what had taken place. Said because she was so distressed the person she spoke to did not understand her. And then it jumps straight to paragraph 9. Our client was invited to attend the council offices on the 7th of July to explain what had happened. She was told the property was no longer available. So again, no reference to 4th of July. And the gist of what's being said is perhaps spelt out towards the end of that page, 5 lines up from the bottom. At no time did she refuse the property, but she was not able to sign the tenancy agreement in light of the serious distress caused by the meeting with Sanctuary. That she was in distress would have been clear from the way she presented, and indeed, I think agitated is the word that we've seen the housing officer use to describe it. If we turn then to page 28, there is then a brief letter from the GP.
Had the writer of this letter from your instructing solicitors seen Ms. Nikolaeva's letter of the 3rd of July?
I can take instructions.
There's no mention of it.
No, I think that's right.
Yeah. All right, sorry. Obviously, it's not a criticism of her. I'm sure she would have mentioned it if she'd been shown it, but
yes,
these things don't always happen.
And there is then, I was just flagging up, although I think I don't need to perhaps take the court to it, but there is at page 28 a GP letter. And then, I think more relevantly, page 29, there are some detailed representations. And importantly, on page 30, under the subheading reasonable for our client to accept the property, they quote the guidance that that we've looked at, and then go on and really from page 31 onwards, focus on the mental health issues, talk about what happened before with the previous offer, and spell out why, given her particular vulnerability, she hadn't been given a reasonable opportunity to consider the offer. And just lastly, to note that one of the ways that's put at page 33 is under the Equality Act, and there's an argument run that she's a disabled person, it's a reasonable adjustment. I mention that because it helps make sense of the structure of the reviewing officer's letter. What that prompts is a minded to letter from the reviewing officer, setting out the reasons why he's minded to uphold the decision. And we don't have in the bundle that at first minded to letter, but more important, I think, are what we do have, which are the reps written in reply, and they begin at page 36. And the court will see, first sentence, we write in response to the council's minded to letter. And the passage that I'll ask the court to look at is at page 40. And it's paragraph 19. And it says on 3rd of July, the council spoke to Sanctuary Housing, who advised property would only be held until tomorrow. By this point, I think this list has seen the housing file. They did not want to lose the rent. On the 4th of July, the council spoke with our client over the phone. The council's minded to decision letter states on the 4th of July, advising that we were taking her refusal to sign the agreement as a refusal. There is evidence if, at the time of this call, sorry, I think that there's a missing no there. There is no evidence if at the time of this call the property was still available, whether it was offered to our client during this call and what discussions were had with her to address her concerns. An appointment was arranged with her client for 7th of July, by which point the property was unavailable. So in other words, what had happened was original decision focusing on 29th of July, of June. There's a minded to letter saying, well, hang on, what about the conversation on the 4th of July? And this list is saying in response, well, look, there's no evidence that actually there was any re-offer at that stage or any refusal at that point. And then lastly, there are the final reps that are put in, which begin at page 62.
After the review.
No, this is the 1st of October 2018, so this is after another minded to letter, but before the review is concluded. And if one looks at the 3rd paragraph down, the letter says we attach a brief chronology, which I'll turn to in a moment. But the second bullet point really spells out what the appellant was saying. Our client was given one opportunity to sign the agreement, but was not at any time provided with the agreement or the terms and conditions of tenancy to read. She disputes your contentions, particularly at page 36-39, but also disputes any suggestion that there was any other opportunity to sign the agreement. So she's specifically saying, look, 29th of June was my chance. It wasn't re-offered on the 4th of July. And that...
I think you're overstating things. I mean, we're in danger of going back over the whole material again. 29th, I'm not signing. 3rd, the letter. There is notes in the tribunal, in the council's offices saying, we've got that, we're trying to ring her to tell her that we don't treat the reasons for refusal as valid, effectively. And then they get the note or the message from Sanctuary saying, we'll have to take it back. And the next day, the note, as my lady says, is very short, but it says, spoke regarding letter and reasons for refusal. If you read it as a whole, it's pretty clear. It's not a question of, will you have it? when they spoke to her on the 4th, the natural implication is they said to her, those are not good reasons for refusal. And she did not say, in that case, I'll accept the property. She maintained the refusal, as she did at the meeting with Mr. Sharma on the 7th. It's trying to say the council must do it in a particular way by taking guillotine and other points and saying they haven't done it in that way, therefore there was no refusal. It is clear there was a refusal on the 4th. Well, she wasn't accepting the property.
And what she says about the 4th is set out in the chronology. It's page 65. Yeah. So this is what she had said about the 4th. 4th of July 2017. Officer for LBR at Redbridge spoke to Nata Nikolaeva in a telephone call. NN says, was not given any opportunity to accept in this call. The officer called back and told NN to attend the office on the Friday. So she is saying, of course there's a distinction, isn't there, I'd submit, between a discussion that says, look, you refused it last week, you told us your reasons for refusal, you spelled them out in the letter, they're not good enough. There's that situation. And there's another situation where the officer says, they're not good enough, will you accept them? We'll give you one opportunity now, one more opportunity to accept it. The appellant says no.
So all of this turns, Mr. Chataway, on you're saying that the officer on that occasion, on the 4th, did say, we've got your letter of the 3rd, your reasons are insufficient. And you're saying, rather than saying, and now I give you an opportunity to change your mind, that is what's missing. That's what you complain about. And so the difference is between whether there's a duty, if you put it that high, to do that on that occasion, or whether in the face of what is quite clear refusal and the reasons for that refusal, and an explanation that they are not sufficient, that would be enough, and that on that occasion, at that point, the applicant would have had the opportunity to say, okay, I'll have it. So it's the difference between, all right then, okay, I'll have it, and actually expressly saying, in those circumstances, do you still refuse? That's it in a nugget.
Oh, but a crucial difference, because if one is talking about it merely as something that has happened, a historical event, then there would not be that second positive refusal.
But why were they calling her? They weren't calling to say, well, they just called to say, we've got your letter. As a matter of history, we would like you to know, we have considered it, but the reasons are not accurate, goodbye. They rang her, they were chasing her because the sanctuary were chasing them. They wanted to know what she was doing. And the fact of the matter is, her position was then, and it was at the end of the week, I'm not taking this property if those are the rules.
Well, she had said on review, all that happened on the 4th of July is she's told to come in for an interview. That's what these representations say. So it was a factual issue, which I say the review officer was required to address.
We're going to go over the supplementary bundle again. You've got to look at the notes. That's not what happened. There was the note in the council thing saying, we've got a letter, we don't accept the reasons. You've got the call from Sanctuary saying, we need to think about taking the property back, or worse to the that effect. They try to ring her, and they ring the next day, and the note says, spoke to applicant regarding reasons and refusal. It wasn't spoke to applicant to arrange an appointment. That was to happen as well, but you're really perhaps trying to take submissions that were made afterwards as to how a set of events might be interpreted. And really, I think, isn't it a question of looking at it reasonably? Is there any basis on which the reviewing officer could have taken a different view? That there was the viewing, there was the meeting on the 29th, there was the letter on the 3rd, there was a conversation on the 4th, and on the 4th she was maintaining her position that she wasn't taking it.
Well, I say it is, I mean, of course it's right, the review officer, it's the review officer's decision. We have to look at the way that the review officer dealt with it. But it's not a bare rationality challenge. I'm not saying the findings of the review officer were just straightforwardly irrational in the face of that evidence. What I am saying is that when we look at the review decision, we find he misread the evidence and confused the evidence.
All right, now you've been promising for quite some time, Mr. Chataway, to take us to it. So I think we're done with 2017, aren't we? We're now on to the 6th of December 2018 letter, tab 11, page 82.
Exactly, and very long letter. Broadly speaking, divvied up into 5 bits. There's an opening account of the background. There's then a relevant bit from paragraphs 31 to 56 about, under the heading, did your client refuse the offer? There's then an extended discussion about suitability, and lastly a bit about the Equality Act. And it's really the refusal bit in the Equality Act that set out the finding. I've, in the skeleton, listed a number of passages which I show that the review officer made a finding that there had been a refusal on the 4th of July and that he relied on it. Now, that's disputed by my learned friend, but there are basically 2 things I think I need to show. One is that he made that finding, and relied on it, and secondly, that it resulted from a misreading of the evidence, and rather than perhaps, well, I'm going to jump straight really to the second point about the misreading. If we turn to paragraph 33 of the decision, this is really, I submit, the key paragraph, and I just invite your lordships and your ladyship to reread the whole of 33.
Yes.
And the key sentence I ask your lordships, your ladyship to note is that one right in the bang in the middle of the top of page 86, 6 lines down. In fact, I note that the officer noted that your client's refusal was specifically because of the communal garden, which would indicate to me that your client was actively refusing the offer of accommodation. I'm mindful that it seems reasonable for the allocation seem to have taken this as refusal of the offer. So unequivocally, what the review officer is saying, look, I've looked at the notes. There was not just a generalised, not just a call, but a discussion, a noted discussion with the housing officer when you discussed the garden, etc. And it was reasonable, and that proves that on the 4th of July there was this active refusal. But the notes, we've seen the note of 4th of July, it doesn't say anything at all.
Yes,
about
this letter may be confused, but again, there's such a danger in taking one sentence out of context. You started at 33. Actually, at 32, it says your client was saying that she didn't refuse to sign the agreement at the meeting on the 30th of June, but wished to seek advice. And this paragraph is dealing with whether or not he thinks that's what she reasonably was saying at the agreement. And then he's got the sentence that you say is the wrong sentence because it notes about the communal gardens. And he finds that she wasn't really seeking advice. And then you go to paragraph 34, and that's where he begins. I must, however, point you to the 4-page letter provided by your client dated the 3rd of July. Your client clearly refused to sign the agreement. So it's possible that he's made a mistake when he's considering the chronology from the point of view of was she correct to say that all she was doing on the 29th of June meeting was not refusing, but saying, I want to take advice. And indeed, she was advised to speak to somebody. But isn't the key point 34? When you get to the 3rd of June, Mr. Chataway.
Well, but one has to look, of course, this is the review officer's decision.
Yeah.
And one has to look at whether the review officer made a lawful and rational decision. And the reference at the end of that paragraph, the final sentence, is really important. It's a reference to this Asplin and Westminster case, which I think needs a little bit of explanation. But basically, Asplin and Westminster is a case where an applicant was offered temporary accommodation, they refused it, they asked for a review, and a few weeks later the review's done, and they turned around and said, well, right now the property's not available, so I'm off the hook. And unsurprisingly, short shrift given in the Court of Appeal says, the Court of Appeal says no, relevant date is the date of the refusal. So that's the significance of the reference to Asplin. It's saying that the fact that your client was considered to have refused the offer on the 4th of July is the relevant fact.
Yes.
So this is where the review officer is saying that's the key point, if you like, where the guillotine comes down.
Well, suppose the refusal is not conveyed by the oral discussion of the 4th of July, but by the relevant officer opening the envelope and reading the letter posted on the 3rd of July. It's the same result, isn't it?
But what if one looks at what the review officer actually decided?
No, I can see that you say paragraph 33 amounts to a finding of fact that the refusal is contained in an oral discussion of the 4th of July.
Yes.
I suppose he's wrong about that, but the refusal is contained in the letter. Does it matter?
Well, it certainly matters in the way that the court should approach the case, because if the court is going to substitute its own decision for the flawed decision of the reviewing officer, then the test is very different. I'd submit the court ought to only substitute its own review decision if it's saying that strip out the mistake about 4th of July and it can make no difference. It's inevitable.
Well, if you look at 34, really, I mean, I know it's a long letter, but one really does have to look at everything. You just can't take sentences out of context. Is there any doubt that the thrust of this officer's decision is the offers have been refused? It's clear from the letter,
yes.
Certainly by the 4th. And if the answer is by the 4th it had been refused, and this court thinks it was clear by the 3rd, but there may or may not be clarity about the 4th, is there any difference?
Yes, because it's one thing for the review officer to say, I find there was a discussion about the offer on the 4th of July.
If that was all he found, but if he said she refused on the 29th, I don't believe she was asking for advice, and I look at her letter and she'd refused by the 3rd, and I think there was a conversation on the 4th, if we were satisfied with points 1, 2 and 3 that up until and including the letter of the 30 was right and she'd refused it, would it make any difference that there wasn't a further refusal?
I submit it would.
Because
Because it's one thing to say you had a discussion on the 4th of July and you were given a further opportunity to accept and you refused it, and in that context I am satisfied that you had a reasonable opportunity to consider the offer. That's one position. It's very different from saying, well, no, actually, you didn't have the conversation at all on 4th of July. In fact, you didn't speak to anybody before the offer was closed, but nevertheless, you went to your sign-up, you refused on the day, and over the weekend you wrote your letter, and that's enough. It's a very different value judgment to make, particularly when you look at the vulnerability of the applicant and her mental health issues. And so I say the review officer does very much rely on a careful discussion on the 4th of July. And that is the basis for him saying, that's the refusal I rely on.
Well, I think you are taking that, you're putting a lot of weight on a couple of sentences. You need to see the context. He is talking at 32 about her statement that she was seeking advice. And he says, no, I don't believe you were seeking advice. I believe you were maintaining your refusal.
Well, I will take to the other passages in a moment where I show, which I say demonstrate his reliance. Before I do that, I want to spell out the confusion. This reference to communal garden, I submit, plainly shows he got the records mixed up, because there is a reference to a communal garden. It's at page, I think, 15 of the supplementary bundle. And towards the bottom of you'll see that sort of final bullet point, where it's recorded also, I think, I'll read through what I think it says. Also, agreement, in other words, tenancy agreement, cannot put her flower pots in garden, told the gardener deals with the garden. That's it seems, to me, clear, that's the record.
Well, it's actually more likely to be page 10, which refers to communal garden.
That's what I was going to say.
Oh, sorry.
And surely, if one looks at that, and then at page 10, and then looks back at page 33, that is what he's talking about in the passage you've referred us to in paragraph 33. And he isn't linking it directly to a discussion on the 4th at all. If you read the paragraph together and in context, he's looking at whether there had been a refusal, or whether she was seeking advice, and he was looking at the evidence about what her position had been, and it doesn't say that discussion took place on the 4th at all.
Milady, I mean, that doesn't fit with my reading of it, I have to say, because this paragraph is all directed towards, if you look at the beginning of it, London Borough of Redbridge spoke to your client about this on the 4th of July. And that whole paragraph is devoted to what is said to be the content of the discussion, and indeed...
No, I don't think so, because if you look at the last line on page 85, paragraph 33, in the middle, I'm satisfied, therefore, that at this point your client had had the opportunity to change her mind, etc. And it's in that context that he's looking back at what had happened and what was the situation.
But if
that's how I read.
But if one reads on to the next sentences, the information recorded by the officer that spoke to your client does not indicate to me that she was seeking advice or clarification.
Well, but that is ambiguous and can refer to page 10.
Except that that's not what it says, because it goes on and says the officer noted that.
Yes, the officer does note that on page 10. I think we disagree.
Yes. As to why the review officer made the review officer plainly found there had been a discussion during which there was an active refusal on the 4th of July. That much I submit is clear from him saying, focusing on that date, saying that is the relevant date. I submit he very much did rely on it, and we see that from elsewhere in the decision. I'm not going to go through all the references in the skeleton, but I will highlight the following ones. Paragraph 38 on page 87. If one starts 9 lines up from the bottom of paragraph 38, I'm mindful that the officer that spoke to your client on 4th of July was clear that your client was refusing the offer of accommodation and that there was no ambiguity about her wanting to accept the offer or wishing to have aspects of tenancy explained. And then if one turns to over the page to 43, end of 43, 6 lines up, she clearly spoke to an officer at the Housing Aid Centre on the 4th of July, but still did not agree to sign the tenancy agreement, despite the fact that the officer spoke to the Housing Association. Had your client advised at this point she wished to sign the tenancy, but the Housing Association were not willing to allow her to, I'm mindful that I might have viewed this matter differently.
What's wrong with that?
Well, again, it's finding that there was a refusal.
No, she spoke to an officer at the Housing Advice Centre. Well, she did. But she still did not sign the agreement. No, she wouldn't.
But when you couple that with the review officer saying 4th of July is the operative date, an active refusal.
Yeah, but that's not those sentences. You've got to have the other things.
Well,
if there was any indication on the 4th that she wanted to change her mind and the authority said too late, you'd have been taken a different view. And if the 4th of July conversation had been different, if the conversation really had been, okay, I'm changing my mind, I know what I said in the letter yesterday, but I'm changing my mind, it is inconceivable that the note would not have recorded N changed her mind, ! Rather than spoke to applicant regarding her letter and refusal to sign the tenancy
and
agreement.
indeed, I'm not saying that that's the case. I'm saying that on the evidence that there's no decision made one way or the other on the 4th of July and no refusal, positive refusal at that date. And then just lastly, importantly, I think, there's the end of the letter deals with the Equality Act, which is of course because that's one of the ways it had been put that she should have been given time because of disability. And what the reviewer says in his view, she's not a disabled person under the Act, but it does in these passages show again that he's relying very much on a positive refusal on the May 4th of July. And I say that because if one looks at page 99, um, 127, he says this: I'm reminded that arranging a viewing when none was legally required and speaking to your client to ensure that she understood the potential implications of refusing an offer of accommodation, appropriate steps. In other words, what he's saying is, because of the health issues and so on, it was appropriate to discuss with her the offer and make sure she understood the implications of refusing. And then in the next paragraph, I'm mindful that an officer spoke to your client the Monday after. I think it's a typo, it ought to be the Tuesday the 4th, after the abortive sign-up, giving her the opportunity to ask to sign the tenancy agreement. No evidence that this happened. So again, he's relying very much on the 4th of July. And then lastly, paragraph 34 over the page, as such, I am mindful that sufficient reasonable adjustments were made for your client and that she was given ample opportunity to accept. In addition, I'm mindful that she specifically spoke to the Housing Advice Centre about refusing the offer and the possible consequences. I'm not mindful that she was making this decision without understanding the potential consequences. It all, I submit, it shows that it was central to the review officer's decision that the appellant made a further decision to refuse the offer during a conversation on the 4th of July when her options were discussed and she was invited to agree to accept it. And I submit that the attendance note really doesn't bear that out, because all it says is there was a discussion which may have been about historical.
No. Spoke to appellant regarding her letter and refusal to sign the tenancy agreement. In context, we know what that means.
Well, I submitted what I say.
The judge deals with all this by saying that it's hopelessly unclear from this long review letter on as to how, or rather at what time, the refusal of the accommodation crystallised. But, he says, paragraph 75 to 77, in the end it doesn't matter because he accepts Mr. Mullin's submission that by the 4th of July, there was a refusal that began on the 29th of June and was maintained up to and including the 4th of July. And the central question, it seems to me, is whether that's a legitimate way of describing the approach to the case as contained in the review letter. Is that sustainable in law? You say that the review letter you say that the decision has to identify a date of refusal. Paragraph 33, it identifies the 4th of July. That is wrong because there was no refusal on the 4th of July. Therefore, the case has to be reconsidered.
Exactly, and because he uses the terms active refusal in 33, I submit, and also this decision in paragraph 134, which is talking about a refusal decision, and it highlights the importance of the point made about the Act, that failure to accept or a failure to reconsider is not the test. The test is there a refusal, an identifiable refusal? And it means, with respect, that there is all the difference between a discussion about a refusal that's already happened and a situation where an applicant is told, well, look, it's still not too late. It's open to you to accept this, notwithstanding the fact that Sanctuary said the tenancy was due to start on the 29th of June and you refused and you walked out of their office. Notwithstanding all of that, it is still open to you to accept, and we think you ought to do it because your reasons frankly stand up to nothing.
Just looking at the powers of the court, on appeal, the court, that's the county court, but it must mean this court as well. On appeal, the court may make such order confirming, quashing or varying the decision as it thinks fit.
Yes.
If in fact this court were to regard it as tolerably clear that on the 3rd of July A, she'd had enough time, and B, she refused it. Why can't we vary it or affirm it for slightly different reasons?
Well, applying sort of the usual public law test, if you thought that was the inevitable result, the only conclusion open to the local authority, then I agree, certainly, that the court has the power to do that. But one has to bear in mind two things, I say. I mean, one is that there was a factual dispute raised about what had happened on the 4th of July. You know, the appellant expressly saying, I wasn't given the opportunity.
She says, I went for advice, is what she said.
Well, what she said in the chronology was that I was not given any further opportunity to accept.
But we've got the decision, and that's your view of the evidence. But in his letter, what he said that he said she asked for advice, and I didn't believe that she did ask for advice. That's one issue. But that's please don't go over the facts again.
Yes.
We do know the facts.
Yes. Okay. So
what would have to be before we could say it doesn't make any difference because he would have decided the 3rd of July, and that would have been a lawful decision. Before we could reach that conclusion, what would be the constraints?
Well, I'd say that one has to really look carefully at the matters raised by the guidance, mental health issues, etc. The confusion about the status of the tenancy.
Yeah. If we take all those matters into account, and it's clear to us that he would have decided by the 3rd of July in any event, and if we decide
even before she had actually spoken to anybody from the council itself, if the court were to take the view that that was the inevitable result, then yes.
Right.
Well, isn't the test to be applied that the one given by Lord Newburger in the Holmes Morehouse case is if we find that that the decision maker in the review decision made an error, is it obvious that the decision would have ended up the same even if the error had not been made?
Yes. And just, I mean, the Holmes Morehouse case is in the authorities.
Yeah, but it's just that last paragraph, isn't it?
Yes, and perhaps if we look at it very briefly. It's
tab 7, paragraph 51.
I'm grateful.
I don't know whether we need anything else from this decision. That's the only bit I've read.
And that's right. I would just ask that the court also have to have regard to paragraph 46, which emphasises that the responsibility of the judge on considering the challenge is heavy because of the issues concerned, not least in this case where the appellant's been there for 16 years now. So is it obvious? Well, again, I agree that is the test, but when the review officer did discuss at length the events that followed and repeatedly referred to the discussion with the housing officer on the 4th of July, I'd submit that that's an indication that it's not obvious. And if one strips away all those references, what one is left with is a finding that she went on the day, she was caught on the hop, she panicked, she refused to sign a tenancy that was due to start that day. And in that context, one would need to be satisfied both that the letter and so on were an active refusal, and that despite what had happened on the day, it was reasonable. She had had a reasonable opportunity to consider things, even without the discussion with the housing officer, where she could have raised, for example, the issue about the mismatch between the council letter and the sanctuary letter. Unless I can help your lordships or your ladyship on ground 1, that's the main ground.
Yes.
Just, I think ground 2 very briefly.
Yes.
I mean, it really turns, I accept, on the same finding, that there was some, that the review officer relied on a refusal found to have been made after 29th of June. And I say that if the review officer was doing that, then he needed to be satisfied that the offer was still available, still effective, in the sense that if it were accepted, it would give rise to a tenancy. And that was put in issue because I think, as we've seen, the solicitors had said in the course of the review that it was not clear whether the tenancy had been available. And that, the reference for that is the passage which we, I think, did look at on page 40. And the way that the review officer dealt with it, I submit, is in paragraph 33 again. And this is in the core bundle, page 86. And it's the sentence that begins at the very bottom of page 85. And this is all the paragraph which I say is talking about 4th of July. We've got the reference to the 4th of July in the first line of 33. And it says, I am satisfied, therefore, that at this point your client had the opportunity to change her mind and say she would be accepting the offer and would sign the agreement, as at this point the accommodation was still potentially available. And paragraph then 43, page 88, again it's that last sentence, 6 lines up from the bottom. She clearly spoke to an officer at the Housing Aid Centre on 4th of July, but still did not agree. Had your client advised at this point that she wished to sign, but the Housing Association were not willing to allow her to, I'm mindful I might have viewed this matter differently. So what he's saying, I submit, is that it might have been available at that stage. But that isn't an answer to the solicitor's objection, saying, well, look, you need to be clear it was available. And I submit that that's what the Act requires, that it's an offer of accommodation that comes down like a guillotine.
If it's the 3rd of July, it was available in July.
Well, we know the Housing Association were willing to accept.
Yeah. And then they weren't going to take the property back, as they put it, until later, after the 3rd of July.
Yes. And I accept your Lordship's point that it's unlikely that if they'd nominated Ms. Nikolaeva again, then that would that they'd have refused.
And the 3rd of July, contrary to the obvious error in paragraph 34, was a Monday, not a Sunday.
Yes.
Is it not?
That's right.
That's don't know where Mr. Waldron got that from.
And that, I think, is what leads him then to go on and get all the other dates wrong. Unless I can assist your Lordship's ladyship.
Thank you very much. Well, we'll rise there and return to fly past 2.